So hello everyone, and welcome to the Bonavero discussion group. On this very bright and sunny day here in Oxford, we're delighted to have with us Raphael Fazer, who will be talking to us about his new book with the title More Equal Than Others, Humans and the Rights of Other Animals, that was recently published with OUP. Raphael is a Yates Glaser Book Fellow, a college assistant professor and director of studies in law at Jesus College, and affiliated lecturer at the Cambridge Law Faculty. Today he will be joined by an excellent panel that will discuss his book. For those that claim that Oxford and Cambridge are not getting along very well, we have two of our very own here, the Freya Bettens, Professor Freya Bettens, Professor John Herring, and the third in the mix, last but not least, is George Letsas, who is the chair in the philosophy of law at LSE.
Sorry, UCL.
UCL, I got it.
That's like conflating Oxford and Cambridge. Right. It's a mortal sin.
Okay.
We are in Cambridge, right?
Well played, George. Apologies, he's with UCL. So now we can start without further ado. So I'm going to give the floor first to our presenter. He's going to be speaking for about 20 minutes about the main arguments of the book. The book is this one, by the way, for those also being online. Thanks, Freya, for lending me your copy. And then we're going to move to our discussions. Please.
Excellent. Well, thank you so much, Christos, for the kind introduction. And thanks, everyone, for being here. Those who are joining us in person, especially on this sunny day, appreciate it. And those joining online, too. So it's a real pleasure to be able to launch my PhD book with you. It's been a long time in the making, so it's a real delight to be here. Just to give you some background, what's the starting point of this project? Just trying to figure out the clicker here. Something's happened here. Okay, yeah, I think it's working now. Excellent. So, for those of you who haven't come across it yet, there have been litigation efforts in quite a few countries now to secure some fundamental rights or legal personhood for non-human animals, and there are also some legislative efforts in countries around the world. And I'll just focus on one here. And this is a citizens' initiative that was brought in the Swiss canton or state of Basel City, where a group of citizens have initiated a vote by the citizenry on whether the cantonal constitution should be amended so as to protect not just humans' right to life and to mental and bodily integrity, but also all non-human primates. The animal rights proponents saw this as an important, symbolic step to extend rights beyond the human species, but that's precisely also what worried a lot of human rights proponents. And the cantonal executive, actually, which gives guidance to the citizens as to how they should vote on initiatives of this sort, they came out strongly against the initiative and advised the citizenry to reject it.
Georgia, maybe you can operate
Maybe just a click. There we are. So this is what the executive wrote to the citizens. It said, if fundamental rights were also granted to non-human primates, this would blur the line between humans and animals, and our fundamental and human rights would be watered down and relativized. And this sentiment is really sort of representative of broader concerns that have been raised against these animal rights initiatives and sort of proposals more broadly. And the question really that the book tries to address is whether there is a way to extend fundamental legal rights or other legal entitlements and statuses like legal personhood without jeopardizing human rights, without watering down human rights. And I tackle this question in three broad parts: a historical part, a conceptual part, and a practical part. let's start with the historical bit. As I tried to show in the first chapter, there's this commonplace view that the modern animal rights idea is a thing of the 20th century, specifically the late 20th century. I'm sure you've all read, or heard of Peter Singer's Animal Liberation, Tom Regan, The Case for Animal Rights, and other works. But what I discovered building on other work is that the idea of animal rights, the modern idea, can really be traced to the 18th century, specifically the French Enlightenment. And I think that's quite an interesting insight for those who are interested in human rights, because obviously human rights are often traced back to the 18th century. And what I argue in the book is that human rights and animal rights didn't just emerge at the same time, but they emerged in tandem with one another, in conversation with one another. So if you want to understand the history of one, I think you need to understand the history of the other two. Just to draw this out a bit, in the book, I focus on the writings of two French philosophers of the time, Jean-Claude de la Mettrie, whose main work you see depicted here to the left, and Jean-Baptiste Salaville to the right here. So who was Jean-Claude de la Mettrie? He was a proponent of a stream of thinking that became really prominent at the time, naturalism. So a very empirical way of looking at the world. And he and other naturalists thought that humans are part of a continuum of matter, and they are not separate from other parts of that continuum, including other animals. And he made the quite striking proposal that because non-human animals are sentient, they should have three fundamental rights: the right to life, the right to health, and the right to plaisir, as he called it, or sort of enjoyments, you might translate it. This approach was criticized by your writer on the right here, Salaville, and he adopted a sort of a counter way of thinking, a different stream of thinking that was prominent, surfaced at the time, egalitarianism. So for Salaville, humans are not part of a continuum of matter, rather they are separate, they are distinct from all other creatures. And to him, the idea of extending rights to animals is very problematic because precisely it would water down human rights, just as the cantonal executive, feared it would. So he had the same worries a couple of centuries earlier. This brings me to the conceptual part of the book, because what I'm trying to show in the book is that these two thinkers and the streams of thinking they represented, they're not a thing of the past. These ways of thinking are still very important today, and in fact, they characterize what I call sort of two ideal types: the aristocratic conception of fundamental rights and the meritocratic conception of fundamental rights. Let's focus on the first one, the aristocratic conception, to sort of see what I mean here. The aristocratic conception of fundamental rights is following the sort of Salavillian, the egalitarian way of thinking, and it is, I think, dominant in current human rights practice and human rights thinking. Jeremy Waldron and others, I think, have described this really well when talking about human dignity and human rights as aristocratic concepts, right? So the idea here is that just like noble people had a high rank, just because they're born into a noble status, all human beings have a high and equal rank, right? So it's the idea of nobility, of aristocracy. This is very much inspired by 18th century egalitarianism, and it has two elements. The first element is what I call equal consideration, and this has sort of three sub-elements, and they're all nicely captured in Article 1 of the Universal Declaration of Human Rights, which says all human beings are born free and equal in dignity and rights. The first one to focus on here is born, right? We're born into that status, just as an aristocrat is born into their noble privileges and their noble status. So there's an element of heredity here. The second one is we're all equal. We're equal in dignity and rights. There's the equality element, the second one. And then thirdly, it says all human beings. It excludes everyone who's not a human being, right? So it has this sort of exclusive element to it as well. How do aristocratic thinkers explain these features? They do so in what I propose an internalist way, What's internalism? Internalism rejects the notion that we can ground rights or ground dignity in properties of human beings, in our nature, the fact that we are intelligent, or we have autonomy, or whatever other feature you can think of. They say we shouldn't do that. We should rather start from normative assumptions, decisions that we should all count as equals, or stories that we tell about humans being equal, for instance. Why this internalist approach? I think this is very nicely captured by Anne Phillips, political theorist at the actual LSE. So she's she's saying, if we think the entitlement to human rights to characteristics like vulnerability to pain or capacity for conscious planning, empirical evidence may lead well to the conclusion that some of the great apes qualify for at least some of the so-called human rights. But, and that's an important but here, it may also lead to the conclusion that some humans who currently qualify, for instance, day-old infants who haven't yet developed consciousness, or those in a coma who've lost it, they are not entitled. So once you ground human rights or equality or dignity in empirical features of humans, then you're going to run into the problem that some humans may not have those features, or they may have them to a lesser extent, which would then sort of suggest that they are less deserving of these rights, maybe less deserving of equality. And that's really problematic. So what's the strength of the aristocratic conception? I think it has a real strength, namely that it doesn't make rights and status subject to such empirical challenges. But there's a flip side to this. And the flip side is that this strength is also a weakness. The weakness here is that in rejecting a sort of a connection between rights and status to nature, to reality, you might say in a broader sense, you risk creating arbitrary concepts that exclude categories of beings that may have the same interest that humans, in some respects at least, but don't get any of the rights, don't get any of the sort of status protections, just because. And this brings me to the other ideal type, the meritocratic conception, and it is very much antithetical, as we will see, to the aristocratic conception. It's mirror image, if you will. Just as the aristocratic conception is dominant in human rights thinking, I think this one here is prevalent in animal rights scholarship. It follows the naturalist stream of thinking that we've encountered in de la Mettrie's text a few minutes ago. And it has two elements that mirror the elements that we saw in the aristocracy. So instead of equal consideration, here we have differential consideration, which has three features to that sort of mirror the aristocratic features. So instead of heredity, here we have what I call merit. So you deserve a right under the meritocratic conception, not because you're born into any given group, but if and to the extent that you as an individual have the relevant characteristics and interests that ground that right. So it all comes down to you as an individual and whether you deserve any given right. Your group membership does not matter. Secondly, you move away here from equality, right? Because if there are beings who lack a given interest, if, for instance, you lack an interest in future existence, and therefore perhaps can be said not to have a right to life, if that's the rights grounding interest, then you're not going to have that right. Or if you have the interest to a lesser extent than some others, then you're going to have that right to a lesser degree. So you, instead of having equality here, you have something like a stratified picture, a gradualist picture. And then lastly, and perhaps more positively here, because we're focusing on individuals and it doesn't matter which group they belong to, this is a much more inclusive approach in my view, because it now allows extending rights to non-human animals, to AI, to aliens. Whoever has the relevant characteristics and rights grounding interests will, at least prima facie, qualify for the relevant rights and status. How do meritocrats explain all of this? They approach it differently from the aristocrats. They are externalists, by which I mean they very much ground rights and status in reality, if you will, in capacities that individuals have, in interests that they have. And these are at least sort of partly objective features of reality, as I argue in the book. What's the strength of the meritocratic conception? it is precisely that it can provide a solid foundation for rights. If you want to know whether a given robot, for instance, deserves particular rights, you'll have to determine whether they have the rights grounding characteristics for that right. At least arguably, that's an empirical matter for you to determine. Same story with animals, of course. If we do find that maybe chimpanzees have an interest in future existence, then prima facie they have a right to life potentially. So you can empirically show whether they have those rights grounding interests, and that's a real strength compared to the aristocracy. But there's a corresponding weakness here too, because once you go down the road of looking at individual properties or individuals' properties, then you are at risk of creating a hierarchy of rights holders that I think particularly endangers vulnerable human beings, right? So think again of interest in future existence. There are some humans that some philosophers at least believe to live purely in the present. They would arguably lack an interest in future existence. Does that mean that they no longer have a right to life? It would seem to be the conclusion if you go down that road. So that's quite problematic, I think, for human rights and for human equality. And this brings me to the last and most practical part of this book. As I said, the two fundamental rights conceptions that are outlined, they are antithetical. They have sort of opposite virtues and vices. So what I propose, just as a practical proposal, not to resolve these sort of tensions on a philosophical level, but just practically I say we should strive for a middle ground between these views, just sort of taking what's positive as much as we can and minimizing what's negative. And my finding is that, this isn't particularly original, current legal systems are very much aristocratic, right? They, for the most part, don't give any fundamental rights or legal personhood to non-human animals. So I argue that we should move toward the middle by what I call meritocratizing the aristocracy. It's a bit of a mouthful. Seemed like a good idea at the time. But so moving towards the middle ground is the idea. And how can we do that? Very briefly, I'm happy to explore on these options in the discussion, but I'll look into how the property status of animals could be undone. There's proposals to turn animals into something like living property with its own rights, or you could even grant certain types of legal personhood to animals, either sui generis or the same type of legal personhood maybe that humans have. I also explore some more fundamental rights that could be extended to non-human animals. We already talked about right to life, right to bodily and mental integrity. Maybe right to family would be another relevant right for at least many non-human animals. Then lastly, what I'm keen to sort of show in the book is that there may also be a risk to sort of overshoot the mark and go too far in a meritocratic direction. And to avoid that, I suggest that we should adopt a group-based approach when it comes to extending rights and other legal entitlements to animals. I call it the species membership approach. And this is a bit of an unorthodox proposal because, as some of you may be aware, in animal rights thinking particularly, the notion that what justifies someone's right could be their group membership rather than their individual capacities. There's smacks of speciesism, right? This is, you have Richard Ryder, Peter Singer, this idea that, grounding rights in one's species membership is morally arbitrary. And I say that may well be true in moral philosophy, but that doesn't necessarily mean that law has to take the same approach. In fact, I think there are very good reasons for the law to operate with group-based categories, specifically the species membership category. There's a bit of a call for emancipation, if you will, for legal theorists from the philosophers, as much as we like them, of course. So the species membership approach roughly says the following: fundamental rights and cognate legal entitlements, right? So the focus here is on legal entitlements throughout. Should be extended to animals based on their species membership, not their individual capacities. What's the advantage of this? I think it's pragmatically useful in the sense that it will make the life of judges easier. For instance, judges aren't zoologists. If they're faced with a, say, habeas corpus, action asking them whether a given elephant is autonomous and should, be moved to a sanctuary, they're not going to be particularly well qualified to assess the individual capacities of that animal and whether they're autonomous or not. The species membership approach allows the judge just to rely on, sort of studies available on the basis of species, right? So it'll be easier, will save them some time too. But primarily it is politically useful, I think, in two senses. The first sense is that it allows us to preserve that egalitarian element that I think is vital to human rights thinking. You don't go down the individual capacities road because of the issues that this raises for especially human beings with who are vulnerable, others too. But in addition to preserving that egalitarianism, it also has a second politically useful element to it, which I think is, it does allow us to extend fundamental rights and other entitlements to deserving non-human beings, but in a way that doesn't jeopardize human rights. So that's it from me. Thank you for your attention, and I look very much forward to the discussants and later on chatting with you. Thank you.
Thank you very much indeed, Raphael, for this very well-structured and succinct overview that you gave us about the analysis, but also the main arguments of the book. It's an amazing read. The book itself is very comprehensive, I would say, and very succinct. So I invite you all to buy it and read it. We forgot to mention at the beginning that this is a lunchtime session, so feel free. We have brown bag lunches there, so if you'd like to consume some, please feel free. And I think it's only fair at this point to start with George, that enlightened us about the local London derby between LSE and LCF. So, George, the floor is yours.
Right. Sorry, I was not prepared to go first, but thank you for the invitation to discuss this really important book. I have to say, it doesn't very much read like a doctoral thesis. I don't know how much it was changed, but doctoral theses are not usually engaging, clear, well-structured, have an argument. So I want to praise the author for producing this marvelous book. I do think it's very original. I do think it made me think a lot. One of the things that I think does well is to give us the history of the debates, not only around animal rights, but as the whole point of the book is around human rights as well. And it does so in a very competent and sophisticated way. And I think it's really important to talk about animal rights in the context of debates about human rights as well. So I think that the main message of the book and the methodology it employs is spot on. I want to begin by talking a little bit about the two concepts in the book that do a lot of the work. So it's the contrast between the aristocratic conception and the meritocratic conception. And I think the argument at the end of the book, which is a middle ground, would make no sense unless you went with the author on the journey of highlighting what work these two conceptions have done over the years in the history of moral and political thought. And I think it's very important for us, and it did help me a lot to highlight these are not philosophical views as such, but as the author, as Raphael calls them, they are ideal types. So it's a set of ideas that motivated particular views about human rights and animal rights, as opposed to a full-blown moral approach on the issue. I think that's very important because that allows the author in the end to steer a middle position. If these two positions are philosophically antithetical, then there wouldn't be a middle position, would be mutually exclusive. So that would be impossible. So I think Raphael navigates very well this issue. Having said that, I think philosophers might start taking issue with the way that these two conceptions are being contrasted. And I want to take issue with one of the ways in which these two positions are contrasted, and it's to do with what Raphael just called in his presentation, internalism versus externalism. So the way this contrast works in the book is by saying that internalists don't want to explain the existence of human rights in virtue of some empirical feature or property of human beings. Rather, as he puts it, they tell a story, which is they offer normative hypotheses about why these rights exist. And he thinks that it's a feature of this non-empirical way, or that the aristocratic conception proceeds, that they can grant rights to everybody. By contrast, the meritocratic conception, because it's bounded by empirical reality, it looks for a property, and that property may come in degrees, and therefore then the rights may come in degrees, but also may feature in other species, not just human species. So that's the contrast, internalist versus externalist. So I want to motivate a little bit of skepticism about this contrast, and first begin by saying that there's clearly, I think, a way in which even the most, what I think aristocratic conception, which I take to be the Kantian, does postulate a property about human beings. It's not an interest, but it's a property of sorts, which is our certain capacity to take ourselves as reasons, to appreciate each other as sources of value, and to generalize, to take reasons to be not reasons for me, but reasons for everybody. So the usual Kantian methodology of generalizing moral maxims, not treating people as ends to your means, these all come from a particular attribute we have, which is a moral faculty. So that's that's bounded to reality. It's something we happen continuously to have, but nevertheless it's social value. So there is an element there, which of course you have to build on it normatively. But something about us, something about taking each other as sources of reasons. So I think there's a hook to reality there. And likewise, on the meritocratic conception, it is true, of course, that that conception ties rights to, say, interests. But of course, we need a reason why they are so tied. And that reason cannot be a fact itself. So for every property, empirical property, that the meritocratic conception postulates as grounding rights, there must be a not-fact reason for why they are so grounded. So you need another story. So in the Benthamite story of pain and pleasure, of course, pain and pleasure are empirical things, but the fact that they are grounds for rights, that is not an empirical claim, that's a normative claim. So what you see in both aristocratic and meritocratic conception is that you need a non-empirical reason to ground rights. And I think that is reminiscent and echoes the Humean view that you're going to derive a not from a is. For every fact that you take to be relevant, there must be a fact-independent reason why that is the case. So I think in a way, both to put it differently, both the aristocratic view and the meritocratic view are internalists. And not only that, they cannot but be internalists. Right? Why would pain and pleasure be a basis for grounding rights? And on the Kantian conception, why would capacity for generalizing reasons be relevant for morality? So Raphael puts it, I think, very usefully contrasts founding with grounding. I think ultimately everything is founding, by which I mean you have to have a normative reason for why any property is worthy of generating rights. So I think that's a useful, for me at least, sort of a departure from the way these two conceptions are being presented. Now, does it follow from the way in which your normative story goes, the normative story about why we have rights, as assuming that there is no contrast there between the aristocratic conception and the meritocratic conception? Does it follow on either side that rights would be equally distributed? So Raphael, I think, wants to saddle the meritocratic conception that it has this differential distribution problem, which the aristocratic conception doesn't. And it seemed to me that, again, people on the meritocratic conception might try to dispute this. And they might begin, I think, Raphael discusses this, touches on this in many parts of the book, may begin with, I think, something which intuitively makes sense as a practical matter, which is, even if you believe that the members of the circle count equally, you're still going to have this differential distribution at the other end of some sort. So take human rights. We all matter equally. Do we have the same rights? Well, that's ambiguous, right? Prisoners don't have the same rights as other people because of stuff they've done. So they don't have freedom of movement, for example. Is that a violation of the rights? Well, it depends what you say here. You might say, well, they didn't have the right not to be in prison because they were justly convicted and therefore they forfeited the right. Same with people who are particularly vulnerable. So employers, they have rights that people who don't work don't have. So right to trade unions, to join trade unions. You have to be a worker to join a trade union, for example. So the more specific you make rights, the more differential they will become. So what we have there is a question about where do we raise the philosophical question about who has rights, at the level of specific rights, which are rule-based, or at the level of something more abstract. And it seems to me that when you raise at the level of something more abstract, which is who counts, there is no contrast between the meritocratic and the aristocratic conception, because even on the Benthamite view, everybody counts the same, which is that you begin by taking everybody's pain and pleasure into account. So I think on the most plausible reading, Bentham was an egalitarian. It's just that Benthamite egalitarianism, what you get at the end is not very egalitarian, right? Because your interests then are weighed up in the calculus and you might lose out. But when you start the question, who counts? Who matters? Everybody matters to begin with, right? And then animals on his view and Singer's view count as well. So if you raise the question of equality at the abstract level, then again, you don't see any contrast between the aristocratic conception and the meritocratic conception. So again, I don't intend this to sort of sources of skepticism about the contrast as criticism of the view, because as I said before, Raphael does not present these views as philosophical position, more like ideal types. But I think the more you start to unpacking this tradition, what you find is that they don't really disagree on the fundamentals. Everybody counts and counts the same, and the base of rights is normative, not empirical. They just have different conceptions of those things, and they end up disagreeing at the other end. But again, I think historically the way they have played out is the way Raphael describes it to be the case. It's just that philosophically the landscape is a bit more nuanced. So these are my comments about the sort of the framework of the book. I want to conclude by saying now some things about the proposal, and it does relate to the stuff I said already. So I think Raphael is right to raise the question about how should things look from the point of view of law and policy, separate from philosophical thinking about who is in the circle and what rights they have. But in the book, he kind of presents this as two worlds: the world of philosophy and the world of law, and totally detached. And given my discipline, I have to defend how they are unified. And I think maybe it's the way the claim is put is a bit exaggerated. Not that moral claims or philosophical claims don't matter, but when it comes to law, more things than moral views about rights matter. And they would matter always for a moral reason, right? So it's not as if there's no philosophy done when you decide on what rights to recognize, but there might be a multiplicity of moral concerns that you want to address. So we're still doing philosophy, but now we have other things. And some of the things that Raphael is worried about is judges making claims about which species have which capacities to what degree. So that's one worry that he has, and a second worry he has is about the politics of it and how recognizing particular distinctions might have unwelcome consequences, so side effects. And we know historically that this, of course, has always been a worry, that the way you present a claim may have political backlash and then might take away rights as opposed to expand the cycle. So I think he's both right to have those concerns. Now, how serious concerns are they? It is here that I think I wasn't completely persuaded by the worry. So in the worry about judges, we do, I was involved in I've been following the literature on the European Court of Human Rights climate change judgment recently. And I came, when it was handed out, I read it with great skepticism about the ability of the court to navigate through this very sort of elaborate scientific literature about climate change. I think the court did a brilliant job. It's a really well-reasoned judgment. So courts, I think, will have no reason of principle not to think that they can do a very good job drawing lines. But of course, only if lines need to be drawn in a particular way. Because just like with human rights, the distribution of rule-like rights will be a matter of interpretation. Will animals have labor rights? Will animals have free speech rights? I don't think these questions are that much different from asking, should prisoners have working rights? If they work, should they be remunerated? Now, I don't think these questions can be answered. They will end up in a court, and they cannot be answered without a theory. And even if you go with Raphael and you say, well, all the animals will have an index relevant group, that wouldn't really answer the other thorny question about the scope of the rights, who has it, because they're not answered for human beings either. So I don't think we should be, obscuring or sort of hiding the fact that judges will have to get their hands dirty, and then we'll have to trust them that they can make the right sort of normative calls. And this links into the question about arbitrariness. I don't think we can avoid that, even if we accept the proposal of speciesism, forget now the acronym.
SMA.
SMA, yeah. The really important requirement that we're not arbitrary, either as legislators or judges, will require some reflection on what grounds there are rights. Even if we say, as a default position, we're not tracking the property of the relevant species, we're saying everyone in the species will have it. We still cannot avoid, I don't think, the broader question, or the normative question, what makes the case, not just that species has the rights, but any species has rights. And then, as you say in the book, there will be call for extend the circle. So even if we go step by step, any court will be at the next level facing the question, why this species, not that species, why not trees, and why not woods and tables and so on. So I think, I understand the practical and pragmatic concerns you have, and I think you have a good answer, but I think we really have to answer the question of what makes it the case that any species has the right that it does. Thank you.
Thank you for this great set of comments, George. And Raphael, you're going to have the chance to respond briefly when we finish the round of discussions. Now we move to Freya, if you would like to go second.
Yes, I'm sure. Happy to go second. So first of all, thank you very much for inviting me to read this book. I thought, I'll read it in a couple of hours, maybe write up my comments in an hour, and in the end, I was thinking of this and of this and of this, and I spent 3 days on whatabouterism. But yes, I think it's thought-provoking is an understatement for what this book did to me, at least. I will just pick up a couple of specific points. There's too much in the book, and there's 2 other commenters as well. And the first point is that you write at one point, the problem with the current rights aristocracy is that it arbitrarily excludes all non-human beings from the possession of fundamental rights and legal personhood, despite the fact that some of these beings have similar capacities to human beings. And this sort of made me think, or made me question, you seem to see the possession of fundamental rights and legal personhood as something that is linked, and that, at least according to the rights aristocracies, depends on capacity. And you do point out very well, as you did in your presentation, the risks that entails for disabled people, children, the elderly. And I would say that the law does already connect consequences to diminished capacity in order to limit the obligations and potentially also the rights of certain groups of people, the extent to which you can be held to account for criminal acts, or the extent to which you can undertake new obligations such as signing contracts. But I wonder whether a solution could be not necessarily offering legal personality and then with some kind of restricted form of capacity, but would it be possible to have a category for animals, declaring them to be beneficiaries, but not to have personhood in and of themselves? And that is, for example, in my subject area, what international investment law does with investors. They are beneficiaries under treaties, but they're not rights holders in and of themselves. I was very intrigued by your discussion of the species membership approach. It seems so logical that I was wondering, how could anyone ever argue against it? Well, I have never seen it. It is possible. And it's by and large how we regard human beings, although, as I said, relevant restrictions and extensions can be made. And as the previous commenter already mentioned, you have additional rights or additional protection for certain groups, such as children, disabled people, migrant workers, etc. And these are not made for individual human beings either. They are linked to specific groups, but within the species based on certain criteria, which is not discrimination, which is prohibited, but differentiation on specific relevant criteria, which is perfectly fine. I only wondered how you determine which criteria are relevant. How do you measure mental capacity, and sort of where to draw the line, and how to apply this? And that thought brought me to one of my own research interests. I'm fascinated by interactions between different legal objectives, particularly where there's tensions between those objectives. I think trade and human rights, investment and environment, that kind of thing. Which brought me to what I think are the most interesting pages in the book, and it's rare that you can sort of really pinpoint, but I find page 194 to 198 really fascinating because it's how do you deal with conflicts. And one of the things, I was recently sort of on the sidelines involved with a European Court of Human Rights case, which was brought by Muslims and Jewish organizations in Belgium against the state of Belgium, which was about the protection of animal welfare against the right to ritual slaughter without stunning. I apologize for this. Nobody has lunch at the moment, so okay, that's fine. But the point of the state there was that public morality includes animal welfare, which is a legitimate aim for which the state might justifiably restrict Article 9, which is freedom of religion. And the court agreed with, I don't know whether you've read the case, but in case you haven't, the court agreed that it was possible for states to legislate that animals should be reversibly stunned. For those of you who don't know that particular thing, it's sort of you stun the animal and then you can bring it back to conscience so that the cause of death is not the stunning, but the ritual slaughter, which the state had hoped would be a good compromise, but the organizations thought was not. And I was wondering if you have read the case, otherwise feel free to ignore this one. But would you say the reasoning of the court in this case, where they didn't focus on animal rights, they focused on the rights of humans with regard to animals, so that the public morality rights as opposed to religious rights, where public morality won out because largely dependent on scientific data relating to measuring animal suffering. And is that kind of, is it aligned with what you're proposing, or is it something completely separate? But it is a way that courts at the moment look at animal rights. One particular question I had is, or sort of what other tension is the rights of animals versus the rights of minorities. And if I think, for example, about Norway, which is otherwise a very pro-human rights country, but a strong objection to wading restrictions because of indigenous hunting. And they said this is part of indigenous culture and therefore should be allowed to continue, even though it's outlawed in many other countries. And the final example in this context I'd like to give is, some of you might have read that, it was in the news in the past weeks as well. So several African countries allow for restricted big game hunting, arguing that there is such a thing as too many elephants, and therefore they issue a limited number of hunting licenses that allows them to raise funds, which they say are then used to protect national parks. So the population of wild elephants in Botswana has tripled in 40 years, and there are now regular conflicts between animals and farmers. And that created a diplomatic incident between Botswana and Germany, because there is a legislative proposal in Germany at the moment to prohibit the import of hunting trophies. And of course, everybody who goes to hunt an elephant likes to bring back something from that elephant to, hang up in their living room, I assume. And so what happened was that President Masisi of Botswana said he would send 20,000 wild elephants to Germany, and also demand that Germans adjust to the animals by letting them roam wild, much in the same way. Is that
no? Because they see it's quite cold now, no? So they seem very low. So.
Much in the same way, people in Botswana are essentially told by the West how to deal with elephants. For those of us living in London, there was a similar offer to send elephants to Hyde Park, so you might enjoy that too. And so there was a whole debate about animal welfare there, and the claim was that this kind of arguments, and arguably including yours, although of course your book was not targeted as far as I know, but that is condescending and a sort of a form of a new form of colonial conquest. And I was wondering how you would deal with this, because my main question after reading the book is sort of, I would like to see those 4 pages essentially made into 4 chapters. How do you apply this in practice? So you gave the example of, I forgot the name, but it was an Asian elephant. But sort of, do we then give rights, and it sort of ties in what you already said, to say spiders or mosquitoes? So we generally tend to protect the cute cuddly animals, but how far will we go to protect the life of pests, or what we regard as pests? So you would then create a whole hierarchy of species, and then who would decide this? And you do attempt at having a first go at this by pointing in the direction of political decision makers, and that's actually my second favorite part of the book, which is page 191 to 194. But I just wonder, and again, it's very short, of course, isn't that a bit too easy? And to some extent, isn't that already done? Because political decision makers are engaged in for example, listing endangered species in the context of CITES. But it's quite arbitrary, and it's a very pick and choose exercise. And I do know the work of Anna Peters, that you refer to global animal law, but the whole world does not agree on this. Think of the Botswana example. And then that kind of led me thinking about this whole debate about whether human rights are universal. Are species rights universal? And should they be? Because definitely views on this are not universal as far as I see it at the moment. And you seem to be focusing on a comprehensive approach. For example, you propose that politicians could develop an international agreement on the fundamental rights of animals that distributes these rights on the basis of a species membership. Of course, immediately you admit this is an unrealistic scenario. So I've started thinking about the alternative. And you do refer to this citizens' initiative in Basel, or specific domestic court decisions. But I was rather thinking along the lines, and I would like to hear your opinion, about whether it's feasible to include such rights in, for example, economic treaties, which already refer to animal rights. And actually went to have a quick look at the CETA agreement, which is the trade agreement between EU and Canada that was recently concluded. And both in the regulatory cooperation chapter and in the investment chapter, animal welfare and regulation cooperation with regard to animal welfare, and using animal welfare as a justification to shield government measures, that is already there. I'm not saying that will work at all, but do you see it feasible to bring in your species approach in a way via a back door into such a treaty, which does impact animal rights and which impacts domestic legislation and regulation much more broadly, rather than having a treaty where you already yourself say it's unrealistic? And then I have 2 final questions that go beyond the scope of your book. The first one is, does it make sense to create rights that cannot or will not be enforced? So does it make sense to create rights holders that fully depend on others willing to make the effort to bring cases on their behalf? And linked to that, where will it stop? And admittedly, this doesn't really actually matter. I mean, I'm not a follower of Morgenthau. I've often been told, international law is not law because it can't be enforced, so I will not do that to somebody else. But I was thinking, for example, there have been cases where, for example, a river in Ecuador was a plaintiff in a case where the lawyers representing the river convinced the tribunal that a river's rights were being undermined by a road development project which jeopardized the river's flow, and the river won. Similarly, in New Zealand, a river has been given the same legal rights as human beings, meaning it has to be treated as a living entity. There are calls for protecting entire ecosystems in that way. So some might call this a slippery slope. I'm not saying that's the case. I'm just saying, can what you say, can that be extended, you think? Or is the limit animals? And if so, why? And then a final note, but that's maybe wildly out there, if you give rights to species, should you not also give them obligations? Animals have been sued in the past, so in the preparation for these notes, I have been sidetracked for the best part of a day into the fascinating literature of animals on trial that exists. If you're interested, the most commonly sued animals are pigs, for acts ranging from rioting to infanticide. As recently as 2004, a bear was sentenced to imprisonment in Kazakhstan, and in a prison where there were also human prisoners. Bear was released in 2019 and was sort of rehabilitated with other bears. But so it might sound spurious, but do rights such as the ones you propose in your book, do they come with obligations? And can individual members of a species that has been accorded certain rights be held to account? And if so, in what way? I recognize that particularly the last 2 points go way beyond the scope of your book, but I find it hugely, see it as a sign that it really inspires me. And so thank you very much. I'm very much looking forward to seeing where your research takes you next.
Thank you, Freya. Another round of very spot-on points, and thank you for bringing to our attention these interesting cases in the end. Just to make a disclaimer, my intervention was about the AC, not me being partly German when you were talking about Botswana, sending elephants to Germany. Last but not least, Jonathan.
Thank you very much indeed. A fire breaks out in this room, and you can rescue either the person who's sitting next to you or the chair that you're sitting on. I take it that's an easy choice, that you would always rescue the person sitting next to you. They are of far greater moral value than the chair you're sitting on. Perhaps slightly harder, a fire breaks out and you can rescue a dog or the person sitting next to you. But again, I think most people would feel that the person should be rescued before the dog. But likewise, if the fire broke out and you could rescue either the dog or the chair, well then I think most people prefer the dog. So there's a recognition there, I think, broadly, that dogs and animals need far more valuing than chairs, than mere property, which is where they're regarded in the law. But where they're balanced with humans, perhaps slightly less. Now, if the fire broke out and the question was whether or not you would rescue your mobile phone or the person sitting next to you, that, of course, isn't very difficult. And this is where the crucially important issue where Raphael's book comes in. Where are we to place animals? And how are we to rank them? And I think quite rightly he rejects these two prominent schools of thought, the aristocracy and the meritocracy, he's explained why. In view of the time, there's lots of things I'm going to say, I would like to say, because it's such a rich and wonderful book, but I just wanted to pick up a few things. First of all, I think there's a concern that we have to assume that animals' rights and animals' values have to be found in the same as humans. That the things that we value in humans are what we would value in animals. And the two theories that are being used, aristocracy and meritocracy, are both based on what's valuable about humans. But that's automatically excluding there may be things that are valuable about animals that have no similar relationship to us. And similarly, as we've already heard, to assume that the legal rights that animals should have should be the same as humans have. And that's a very sort of human-centered way of looking at the world. And particularly when looking at the world, I don't think we can make a great claim as humans that we're wonderfully moral and doing lots of good things to the world. So I think we need to be much more open to the idea that animals might have different kinds of rights, have different sources of moral claim than humans do. Secondly, I was slightly concerned by this claim that animal rights will be based not in any kind of moral claim, but simply pragmatic and political. And it seems to me that's enormously difficult in the kind of cases, and Freya and Georgia both already mentioned this, I think. The kind of cases that come to court are nearly always about balancing different kinds of rights or discussing the border of the right. So unless we know what the moral foundation of the right is, how can we weigh up the right to religion or a right to express religion and the freedom of expression, or whether humanism counts as a religion, unless we know what the moral basis is, for example, of the freedom of religion. So I think you're leaving judges with an impossible task if you're saying, well, we're giving animals these rights just for pragmatic purposes, and we're not going to provide any kind of moral explanation behind that. But my final point is I think you've set up a false dichotomy, that there's only two views, aristocracy and meritocracy as the source of moral value. And both of those to me are fundamentally flawed because they're so individualistic. It seeks to locate our value in ourselves, in my abilities or my membership of the species. And I'm not sure that my abilities have any great moral value at all, or even my membership of a human species are valuable. Because what's valuable are relationships, and particularly relationships of love and relationships of care. So if we're seeking to find a source of moral value that might generate claims to personhood, or might generate kind of interests the law ought to be upholding, they're relationships of care and love. And so it's in our communities together, it's in our interlocking relationships where moral value is found. It's those the law ought to be trying to uphold. So I think there is certainly a grain of truth in looking at the species as value, but it's there. It's the species as a group. It's their interaction. They're working together. They're caring and looking after each other, which is of moral value. Not things like independent thought or autonomy or rationality. Those are of no great moral value. It's love and it's care that is. So I think that that's where the meritocracy and aristocracy miss out, that they're just looking at trying to say, right, this single little individual on their own, do they have moral value? Should they have interests protected by the law? Well, no, they don't. But relationships of care and love do. And it's there that we need to have our focus rather than individuals.
Thank you, Jonathan. Very great comments again. I think this was very rich, both your presentation and also the round we had afterwards. And of course, I'm keeping Jonathan last usually because of his presenting style, which revives people when we're in the middle of an event, and moods are going down. Thank you very much, Jonathan. Now you can have 5 minutes to respond if you like. And then, that's the most I can give you.
That should be easy.
Yeah, absolutely. But we might have more time actually, depending on how many questions we're going to have. So,
okay, thank you very much. Well, thanks so much to the respondents for their amazing comments, and it's a real honor to know that you've read the book and found something maybe useful in it, and I'm really grateful for all the challenge and the criticisms too. There's no way I can respond to all of them, but I did my best to actually write down everything you said, so it gives me something to sort of digest on a train back home to Cambridge, and probably in the coming weeks too. So I'll just do some tentative answers, probably missing and forgetting a lot that you've mentioned. So George, thank you very much. I think you're spot on there with a lot of what you're saying. I'm in agreement with. So I think, on internalism versus externalism, I think you're right, and maybe I'm being a bit cheeky in the way I present it, not least because I do then nuance it myself, don't I? So I say that it's true that actually internalists, a lot of them tell stories like the Kantian one that you mentioned, they point to reason, for instance, right? And isn't that some sort of, empirical capacity? And I grant that, and I say it's a founding myth, right? So there's an element here where you do start from something empirical. But the key point that I think remains is that the aristocrats would resist then applying that to each and every member of the human species, right? So they're happy to say, we are special because on the whole we are rational, but they don't think that we can take away an individual human's rights because that individual is irrational. So from that point of view, I think they're not as open to the empirical side as the meritocrats are. And on the meritocrat side, I agree with you, and there too I'm a bit more nuanced, and I say, well, actually, they have this one normative assumption that they rely on, right, as Jean-Philippe put here. So this idea that the good comes before the right and determines the right. And so from that point of view, I think you're right to say that, maybe applying a Durkheimian angle here is helpful. But I'd like to think that some of the tension that remains between the two is still valuable for us to sort of think about, even if maybe on a more fundamental level they're both engaging with normative and empirical points. So I think it's an interesting point that you're raising too. If you go far enough, about abstract versus specific, and the point you're making about Jeremy Bentham, equal consideration of interest, something we find in Peter Singer too. Of course, isn't that similar to the sort of equal concern that we see in human rights thinking, a la Dworkin here? And I think, if you zoom out far enough, yes. And I appreciate your point about we have to apply different lenses and we get different sort of results depending on which lens we use. A point I'm trying to make in the book is, I think, even though they're called very similarly, equal concern for persons accepts that there's this bottom line of the person, right? So it is not equal consideration. It doesn't. It's called equal, but it operates with a different understanding of what's equal here. What's equal is the person underlying it. It's not the individual interests as such. For Singer and Bentham, it comes down to the interests, and equal interests must be considered equally, not persons as such. And that's where I think there's a difference that remains. But I agree with you, depending on sort of, the lens we apply, we do get different results. So I operate just with, I think, what I take to be the lenses that are most commonly used in the discourse. And I think the way you characterize it, is perfectly right. I was too dismissive maybe of philosophy here as I was presenting it, but the point wasn't to say, moral philosophy and political philosophy don't matter. It's just that legal theorists and lawyers should start thinking about their own tools that they have available to them. They're still going to need the philosophy in the background, to resolve conflicts too. So I'm with you there entirely. And I say, for instance, that rights are extended based on the political feasibility. So that's where the politics comes in, but also on merit. And how else are we going to determine merit? And through some moral theory as to, what's good and what rights follow from that. So I'm with you there. Just I want to resist this tendency in the legal scholarship to just want to basically copy paste moral rights into the legal domain, because the law has some extra elements that come into play, as you were saying so nicely. Freya, thanks so much. There's so much here. Let me see if I can just pick up a few points. Beneficiaries without legal personhood. I think it's a really interesting idea. It's just that sort of animal rights people are sort of they're fighting over whether legal personhood is necessary to have rights in the first place. And it's certainly not necessary to have welfare rights or some thin sorts of rights, maybe rights that you could have as a beneficiary of something. The real question, I think, that's unresolved still is whether you can have fundamental rights without being a legal person, whether that's just you have that intimate connection there. And if that's the case, then maybe just using beneficiaries is not going to get you those stronger protections that some people are after here. The reasoning of the courts, I must confess, I've only sort of skimmed it, but what I will say is that it's certainly a first step in the right direction, but you're still operating through a human paradigm here, right? You're protecting animals through human rights and I guess the public interest more broadly, public morality here. I guess that's going in the right direction as far as animal rights people are concerned, but what if the public interest does not, warrant protecting animals' rights? What if there's no human rights that can sort of act as an indirect way of protecting the animal rights? It's not going far enough, I think, for the purposes of a lot of animal rights thinkers. Just conscious of time here. So the pests point, who gets which rights? Again, just to emphasize here, yes, it's a point about feasibility and the political element comes in here, but it's also a point about merit, right? So even if granting rights to flies was politically feasible, which I don't think it is, perhaps flies will turn out not to be sentient, for instance. And if that's the approach we take to grounding the rights, then we might say flies just don't merit the rights in the first place, right? So there's one way of tackling these issues, but I am actually writing another book now with a friend in which we spell out some more of these issues, including proportionality and how it applies to animals resolving conflicts and all that. Are species rights universal? I'm sort of non-committal on this. The species membership approach is a practical tool, and I think that different jurisdictions will apply it in different ways. So whilst I have my own moral views as to universality, I leave it entirely up to the reader to decide where they want to take the species membership approach. Okay, and then lastly, I will say that's a really good point. It's been raised to me before. Does it make more sense to create rights that cannot be enforced by the plaintiffs themselves, right? And should we not rather work through a duty-based framework, perhaps? There's certainly something to it, but we need to grapple with the fact that in the human context and in the context of corporations, we do give rights and legal personhood to beings who are not able to defend those rights in courts themselves. So is this just duties operating and we're just calling it rights for the sake of it, for the rhetorical force of rights maybe? Or is there something going on here that does actually show that it is feasible to extend rights even to beings that cannot cannot defend those rights in court themselves. So more a question really in response to your question, I suppose, and the responsibilities point. It's fascinating literature, political turn in animal rights that says animals should have some responsibilities in, for instance, shared human-animal communities. My dog, Louis was in here before, the dog, and I think he had to leave. So they have to bear some duties, but the key point would be the duties are not sort of a reciprocity requirement for the rights. Again, I'm thinking of human beings here. There are many human beings who cannot reciprocate duties in the way that adult rational human beings can. Still, we think it's important that they have rights. So I would sort of caution that there's a problematic implication there too, potentially. And then lastly, Jonathan, there's actually a friend of mine just told me that there's research showing that some humans actually would be inclined to save their pet over a stranger sitting next to them if a fire broke out. And I think it's precisely because of the reason you pointed out, the relationality, right? They're part of our families, whereas a stranger isn't part of our family. And I think just to sort of end on this, the SMA and how I sketched the debate between meritocracy and aristocracy, it's just meant to be one way of looking at things, hopefully a useful way, but it's not supposed to crowd out other frameworks. Personally, I find the relationality, vulnerability care framework a really important one, but a lot of people are not using that language. So this book hopefully provides a framework for understanding what they're doing, but it's not saying that other moral frameworks aren't potentially attractive or maybe even more attractive.
Thank you very much, Raphael. And